Let me go to torture. During the time you worked in the White House, the Office of Legal Counsel concluded that harsh interrogation techniques were legal, even though Congress had passed a law in '94 banning torture. The Office of Legal Counsel took a sweeping view of presidential power and concluded that the president could override the statute. In response, in 2005, the Congress adopted an amendment championed by our colleague, Senator McCain, I was the co-sponsor, that stated that only interrogation techniques that can be used are those authorized in the Army Field Manual. Was the Office of Legal Counsel correct when it concluded that the president could ignore the torture ban?
So the Office of Legal Counsel, Senator, subsequently withdrew those memos, as you know. And as I've made clear in some of my writings, the review of Judge David Barron's book, some of my opinions as well, the president does not have the authority to disregard statutes passed by Congress regulating the war effort, except in certain very narrowly described circumstances that are historically rooted, the common example being command of troops in battle. So as a general proposition, the president has to comply with the law. The president is subject to the law, including in the national security context. That is the lesson, I think, of the Youngstown Steel case of Justice Jackson's categories. Category 3, as I've said repeatedly in my writings, which is where Congress has prohibited the president from doing something, is critically important. That's essential to the rule of law, as Justice Jackson said. That's the equilibrium of the country is at stake in Category 3, and I've written about that quite frequently.
Got it. Thank you. Today we have a president who said he could authorize worse than waterboarding. How would you feel about that?
Senator, I'm not going to comment on, and don't think I can, sitting here on current events.
Well, but you know what the law is. You've made that clear.
I know what the law is, Senator, and I know you're...
I asked specifically, how do you feel about that?
I feel that I should follow the law as a judge. I know what the law is, and I know your leadership on this issue, both with the report you did, which was the thorough documentation of things that happened, as well as recommendations for the future. And I know your leadership with Senator McCain on the 2005 Act as well. And I know what the law is, and I've written about how the separation of powers works when Congress passes laws of the kind that you have.
One last question on this. In December of '05, President Bush issued a signing statement regarding the Detainee Treatment Act of 2005, reserving the president's right to disregard that the law's ban on torture, disregard the law's ban on torture if it interfered with his constitutional authorities as president. What was your involvement, if any, with this signing statement?
While I was staff secretary, any issue that reached the president's desk, with the exception of a few covert matters, would have crossed my desk on the way to the president's desk. I wouldn't have, in the ordinary course, provided the policy advice or the legal advice, but it would have crossed my desk. So in that case, the signing statement, the drafts of it, that process would have crossed my desk at some point.
Okay. In a 2013 panel discussion, well, you did nothing about it, though. It crossed your desk, and that was that.
Well, there was debate, as I think I've mentioned, about that. The counsel to the president, Ms. Myers at the time, was the ultimate advisor on that matter for the president, and thus would have been the one who primarily dealt with that with the president. It was important in the job I had there not to supplant the policy or legal advisors. That was not my job. My job was to make sure the president had the benefit of the views of his policy and legal advisors.
One more Bush-era question on this. In a 2000 panel discussion at NYU Law School regarding Bush administration anti-terrorism policies, you said the Bush administration went, quote, right up to that legal line to defend the security of the United States, end quote, implying that Bush policies did not cross the legal line. Do you mean to suggest that Bush administration's post-9/11 programs, including the CIA torture program, were legal?
No, Senator, that's not what I was suggesting there, and let me try to provide you an explanation. President Bush's view, as I think he has said publicly, was in trying to keep America safe, he was going to do everything he could within the law. He relied on his lawyers to provide him the boundaries of what the law is, and then he would go up to that line as he thought effective as a matter of policy. It was up to the lawyers, therefore, to make sure that they were giving sound advice and having the backbone, and this is something that your legislation reinforces. Lawyers need to have backbone, even in pressurized moments, to say no. And I've talked about that many times. One of the most important responsibilities of an executive branch lawyer in the passions of the moment, where the pressure's on, where the president wants to do something perhaps, is to go into the Oval Office and say, no, you shouldn't do this. And that's something that I've written about, talked about, and experienced in my time with President Bush. And I've encouraged young lawyers to have that backbone and fortitude to say no. That's about the most important thing.
Thank you.